Is liberty dying where you live? Escape to Keene at freekeene.com.
Mr. Meyer, did you and Mr. Lauren talk over how we're going to go through this today?
Yes, we have, Your Honor.
It's your motion, I guess, I didn't, but he's
Right.
got it.
I was intending to call our witnesses, and then Dave, I understand David wants to make a brief argument first.
Okay. Is there being sequestered?
Yeah, the witnesses are being sequestered.
Are we missing a defendant? Are we missing a defendant?
Yes. Well, Your Honor, my understanding is the defendants do not have to, I advise them they do not have to physically be present.
Okay.
Mr. Hideki resides in Arizona.
Arizona, yeah. I only have two notices regarding cameras. I see two cameras and I see someone with a handheld, so I need to have somebody.
He's with me.
Pardon me?
He's with me through
Okay.
Free Press Publications, FVP.cc.
Okay, so you're under the same.
Yes.
Okay. You have to stay where you are. You understand that, right?
Yeah, he's going to stay here. I'm staying here.
Okay. All right. Mr. Mayor says you want to say something first before you
Yes,
start?
Your Honor. At the outset, the state would like to raise a legal point. The state has 7 witnesses and is ready to proceed with all 7, but the state would like to raise an argument that we may not even need to go that far. The defendants are charged with criminal trespass and not contempt. There are 3 elements to criminal trespass. First, the defendants knowingly 2, entered or remained in any place in defiance of an order to leave or not to enter, and 3, said order having been personally communicated to them by the owner or other authorized person. And there are 3 elements to contempt. A valid court order covering the defendant exists, the defendant had notice of the order, and the defendant intentionally committed acts in violation of that order. As shown by the elements of each, with contempt, the state has to prove that there was a valid order. With criminal trespass, however, Your Honor, the state only has to prove that it was an order made by an authorized or valid person, who in the instant case was the sheriff of Cheshire County. And under criminal trespass, there is no element that the state prove or that it has to show that the order was valid. The state would argue that after having been served with the order, in the instant case, an order that the defendant felt was invalid, their remedy was to bring an action in superior court to invalidate it and not to simply violate it. And in the instant case, the underlying charge is criminal trespass and not contempt. The focus is not really on the validity of the order, but rather if the owner of the property was authorized to serve the order. And in the instant case, the defendants were given the order not to enter Cheshire County Superior Court by a duly authorized person, the sheriff of Cheshire County, and then they knowingly violated that order. And so, again, the state would argue that there really is no need for this honorable court to hold an evidentiary hearing on whether the no trespass order is valid or not, and rather should look to the elements of the crime for which the defendants are charged and indicate that in this case, the remedy, again, is for the defendant to go to Superior Court and file a motion for a hearing to be heard on the merits of the validity of that order. And the state would therefore request that this honorable court hold this case in abeyance and order that the defendants
Hold it in abeyance?
well, not rule on the not have this hearing, not rule on the instant charge, and if the defendants wish to argue the validity of the order itself, that needs to be done over at Superior Court.
Well, when did you know you were going to make this motion?
That was raised peripherally in the state's answer and objection to...
Well, you're making it directly. How much notice does Mr. Meyer have?
Well, he had notice from the perspective of having it in referenced in the state's answer and objection.
Your Honor, I don't really need advance notice to address this issue, although I would request that the permission to file a memorandum afterwards, just so I can provide the court with citations. I think Attorney Lauren is making 2 points. One is that a criminal trespass statute does not require a valid order, and second is that the defendants must challenge the validity of the order prior to violating it. Now, the first of the 2 points is just completely incorrect. I mean, a criminal trespass order is dependent. I mean, a criminal trespass conviction is dependent upon there being a valid order. I mean, otherwise it's not criminal trespass if the sheriff didn't have the legal and constitutional authority to issue the order, the banning order that he did. But I think the more important point is the second point, which is the argument that before a defendant can, that rather than challenging an order through a criminal defense proceeding, you need to first challenge it civilly before the violation of the order. And I guess I have 2 responses to that. First of all, this order was challenged civilly. Now, David said it had to be filed challenged in Superior Court. I'm not quite sure where he got that from. It has to be. It was challenged civilly in this court. The same order in a case called State v. Bo Davis. It was challenged as a civil, essentially as a civil matter, order from the court to allow him to attend hearings without getting permission of the sheriff. That order, actually I said it, no, it wasn't, sorry, my mistake, it was challenged, it wasn't Superior Court.
There was someplace along the line I saw an order or a decision from Judge McGuire.
Right, Judge McGuire, February 15, 2012, which ironically, up until now, the prosecution has relied upon as showing that the order is valid. So that in fact, this same order was challenged civilly in court, in Superior Court, and upheld. So the argument really lacks a factual premise. But secondly, as a matter of federal law, when dealing with this issue, the United States First Circuit Court of Appeals, in a case called United States v. Morad, which is a case from 2002.
How does that spell?
And I'll provide the site in a subsequent memorandum. But essentially what the court said is that although it is the normal rule that a order of this type should first be challenged civilly before being violated, that there is an exception where the order is transparently invalid. And our position is that this order is transparently invalid. So that order would be applicable here, even if, again, even if this hadn't been challenged civilly, which it has been. Now, the final point in terms of David's argument that there shouldn't be an evidentiary hearing is sort of counterintuitive, because the evidentiary hearing the reason we're having this hearing is at his request. In other words, it's the prosecution that has asked this court for leave to put in testimony. And the reason for the hearing today, I mean, our position is that this order is invalid as a matter of law. The prosecution has sought to sustain the order through the introduction of testimony. The court scheduled a hearing for today, so I can imagine no conceivable reason to further delay this proceeding.
Go ahead.
Just very briefly, regarding Attorney Meyer's first argument regarding the criminal trespass dependent upon there being a valid order, the plain language of the statute does not provide that. as opposed to the contempt statute,
So
which does.
what is a defendant to do if, let's say that, first of all, let's say there's no state action involved. Okay? Let's say it's, some landlord has some agent, and they say, we don't want you to trespass. And the agent delivers a letter to somebody down the street, they don't want trespassing on the property anymore. But let's say the agent really isn't an agent. Let's say somebody just took it on their own to give somebody a no trespass letter and said this is from the landlord. And I've got the authority. What does the defendant do? Go to Superior Court and challenge that?
Well, they go to court to, in the first instance, to challenge the validity of the,
No, defendant challenges it within the confines of the criminal case he's charged with. You don't have a separate case on that, and I don't see how it would be any different here. I understand your argument, but I don't see how the reasonableness, the validity, and the constitutionality of the order are I think, right for this court to entertain the evidence on that. It's the defendant's motion. I don't know. Did you say you were going to put on witnesses?
Yes, well, the plaintiff, yes, the defendant is going to call, the court's prepared, is going to call as his first witness.
Well, I'm inclined to go ahead. I mean, I think your issue is still preserved, but I think we're going to have to go forward with the evidence as we plan to do it today. And you'll each do memoranda on that, I guess?
Sure. Very good. Thank you, Your Honor.
Your Honor, defendants call as their first witness Richard Foote.
Please raise your right hand. Swear or affirm anything you say will be the truth?
Yes.
Have a seat, please.
Mr. Foote, good morning. My name is Jon Meyer. I'm the attorney for the defendants.
Good morning.
And sir, what is your position?
I'm the sheriff.
And in your capacity as sheriff, did you issue an order directed to Mr. Freeman, I mean Mr. Bernard, and to Ms. Sniadecki?
Yes.
And what was the substance of that order?
I don't have it verbatim, but basically was to prevent them from coming into the court without our knowing about it.
Sir, could you please identify this order? Sir, is that a copy of the order that you issued?
It appears to be yes.
And that order is addressed to an Ian Bernard. And Mr. Bernard is the gentleman next to me.
Yes.
And was that same order also addressed to other individuals?
Yes.
How many other individuals?
I think there were 4 others.
And who drafted that order?
This is basically an order that the county uses for other county buildings. So it came from the county administration.
From the county administration? Have you ever used that order with respect to the Superior Courthouse before?
No, I have not.
And who made the decision to issue this order?
I did.
And who did you consult in making that decision, if anybody?
Nobody.
You made it on your own without consultation?
Yes.
Now, you said that order was issued to a total of 5 individuals, is that correct?
I believe so, yes.
And who determined which individuals were going to be served with that order?
The people that showed up and were harassing the court staff as they were leaving.
No, who made the decision which individuals were going to be served with that order?
That's why. We watched the people that were
No, but
doing
who
it.
made that decision? The question was, who made the decision?
I did.
Okay. And on what basis did you make that decision?
I made that decision because it appeared to me, as watching on the videos and some experience with the activity of the same individuals prior to this, where they were harassing the people that were leaving the court. After a particular court case that was heard, they were harassing the Superior Court staff and they were harassing the judge. On 2 occasions, I had to send deputies out to intervene between Mr. Bernard and the other 4, so that people could get in their cars and do so with safety. And also with the judge, when he came out the back door to get in his car, it was the same way. And that happened twice, and then they kept coming back. And after, to prevent them from coming back and still terrorizing the people, I made the order. I asked them to leave the property when they were out there doing it, and then I walked them off the property with the other bailiffs, with the other deputies, and then the order came. When they came back the next day, the orders were issued to them.
Sir, are you familiar with the criminal harassment statute?
Vaguely, yes.
Vaguely.
Well, right off the top of my head, yeah.
You're aware that there is a criminal statute that individuals can be subject to for engaging in criminal harassment?
Yes.
Were any of the individuals charged, in this case, are any of the individuals subject to this order charged with criminal harassment?
No, they weren't.
Has there been any finding that any of the individuals subject to this order have engaged in any criminal acts?
They didn't come, oh, yeah.
Has there been a finding?
No.
I'm losing you here. Could you ask your question again?
I'm sorry, was there any determination made by your office that any
Okay,
of
by my office?
Please let me finish the question, sir. Was there any determination made by yourself that makes it more specific? That any of the individuals subject to this order had engaged in any criminal activity?
I'm not sure why we're here. I mean, somebody's been charged with it,
No.
violating this order.
They have been charged with violating the order. I'm asking about prior to the issuance of the order. Was any determination made that any of these individuals engaged in criminal activity?
You mean at the site or anywhere?
At the site, or in or around the courthouse?
I don't know whether, right off the top of my head, I don't remember who they were, but we've arrested people for conduct within the courthouse for violating the judge's order. And so that has happened. Whether or not, I don't remember off the top of my head whether specifically it was one of these, but I know that that group of people had been involved with that.
All right, but you say that group of people?
The people that group of 5 that were here. I don't know whether to describe it.
Let's be more specific. In terms of Mr. Friedman,
Okay.
what did he do to justify your issuing an order banning him from the courthouse? And not in the courthouse, but from any property related to the courthouse?
Showing up, in my opinion, he was harassing or interfering with the court staff that was leaving when they left after work, after there was a court case where there was a finding. And they kept coming back to that, and then they, for at least a 3rd day, I don't remember exactly, kept coming back, and my focus was to remove them from that area so the court staff and others could go home without being confronted by these people.
And that area is the parking lot. Is that what you're referring to?
That's where it took place, yes.
And is it was it your opinion that the court personnel had the right to utilize the parking lot without coming into any contact with my client?
Not any contact. I believe they had a right to go to their cars without being confronted by them and things being said to them.
So my client did not have the right to say things to members of the court staff in the court parking lot?
He did have a right to say things to them. He was interfering with and putting them in fear of what could happen.
How was he putting them in fear?
He's been in their face, up close to them, close proximity to them when they were getting into their cars.
And how do you define close proximity?
Close, like right up close body.
6 inches?
I didn't look at, but that could be that or less.
So you objected to the fact that he was allegedly within 6 inches of court personnel?
I objected to that being part of the conduct that was happening.
Was he ever requested to stand further away from court personnel?
I don't know whether they did or not.
Don't know that. Now, you said that videos were taken.
Yes,
Do you still have possession of those videos?
I don't have possession.
Who has possession of those videos?
We probably don't, I'm not sure, because they rewrite themselves after like 4 or 5 days, because there's 40 some odd cameras that feed that recorder. So,
And these are videos of the Superior Court parking lot?
yes,
And did the alleged offending conduct engaged in by Mr. Friedman, would you say captured by this video?
yes.
And yet you did not preserve the video, but had it erased?
It erases itself.
Did you not have the authority to have it preserved?
I do.
Why did you not have it preserved?
I don't remember what the reason, why that was not. It may have been, I did not order that to happen, but the other people that were involved in this who served the papers may have done that.
All right, may have done what?
May have preserved the tapes.
So you don't know whether it's been erased or not?
That's correct.
Now, in addition to your claim that Mr. Friedman stood too close to court personnel in the parking lot, what else did he do that you believe was improper?
He had a camera in their face.
Was it illegal for Mr. Friedman to videotape court personnel in the Superior Court parking lot?
No,
So that was something he had a constitutional right to do?
he could videotape there, yes.
So I'm not asking you what he was constitutionally entitled to do. I'm asking you, what did he do that he was not constitutionally entitled to in that parking lot?
He came, the other people would be the ones that, witnesses that had to confront him when he came out of there, would be better suited to tell that. But he was in their space with their cameras, and I think that people that have a right to whether or not somebody's taking a picture of them is how close and what their purpose is for the picture, whether they're up close or interfering with them in taking pictures, and I don't know what was said, but they could better testify to that.
Sully, did you interview court personnel before issuing this order?
I did not.
You did not?
I did not.
Did you take statements from any members?
I didn't do the investigation.
Who did the investigation?
One of the other deputies.
Do you know who?
There were several of them involved.
Was a written report issued?
Are we talking about before the defendants were charged?
Yes.
We're talking about before the defendants were charged.
No, I'm not aware, but there may have been.
But if it was written, prepared, you never read it?
That's correct.
Now, you said that Mr. Friedman had a right to videotape court personnel in the parking lot, but he couldn't get the camera too close. Am I correctly understanding your testimony?
He could not get in the camera and get in their face with the camera so close as to bother them or get in their way when they're getting into their cars. And
would it have been permissible for him to film them from 10 feet away?
I suppose so.
What else did Mr. Friedman do that you believe justifies the issuing of this order banning him from courthouse and courthouse property?
It was a continuing.
What else did he do?
I'm going to answer that. That's the question. I'm telling you what it is. It's a continuing conduct, coming back and doing it again, and then coming back again, the same people coming back again, at the time when the Superior Court staff were leaving the office and attempting to go home.
Sir, let me apologize to you if my question was not clear. I was not asking about what other people did. I'm asking specifically about Mr. Friedman. And I'm not asking you how many times he did it. I'm trying to understand what he did that, in your view, justified this order banning him from the courthouse and courthouse property. What did he do?
In answering that,
It's been asked and answered.
What, if the record is that the only thing my client did that allegedly was improper was stand in too close physical proximity to court personnel in the parking lot, if that's the only thing he allegedly did wrong, then I'm not going to ask if there was anything else. I just want to make sure that the record is clear that there's not something else that the sheriff would like to testify to that I'm not giving him an opportunity to respond to.
the court understands your testimony so far that according to what you're saying, that in your opinion, the defendants were engaged in a continuous course of doing the same thing.
Correct.
And what I think counsel is asking is, were there additional things that you haven't testified to already? For example, I'm making this up. Did somebody actually physically assault somebody? Did somebody throw something? Was there something additional to the proximity question and the camera issue?
The other thing being, as I said...
Is that what your question is?
Yes.
The issue is that it was repeated day after day, same activity bothering the people day after day.
And he was asking, is the activity you described with any other
Right, I
any other
understand.
kinds of activity in addition to that?
That I didn't understand his question to be that. The question was there anything else? And part of being that was the repeated day after day activity when the people were trying to leave the courthouse.
So, Sheriff, is it your position that that conduct engaged in by Mr. Freeman would have been permissible if it was done on a one-time basis, but not permissible if it's being done every day?
It's, well, doing it every day. If he'd done it and everything had been over, then he didn't do it again. We wouldn't have gone further than what we did. It was his repeated coming back to the court and creating the same conduct, the same atmosphere for the court staff that precipitated this.
Was Mr. Freeman, to your knowledge, ever told to stand further away from any court personnel in the parking lot?
I don't know. I may have told him today.
You say I don't know or no?
I don't know whether he said it, whether anybody told him. One of the deputies may have, but I did not.
Sir, did Mr. Freeman ever do anything inside the courthouse which was improper and justified the spanning order?
On this particular instance,
Any
other
instance.
times. Oh, absolutely.
Now, in terms of banning him, you issued a banning order.
Right.
Was the banning order based on anything he did in the courthouse?
The banning order was given because of a course of conduct over a period of time that Mr. Freeman and Mr. Bernard had conducted what he'd done in the courthouse over a period of time, and where he certainly has been arrested in there. And that's over a period of time, and this was a continuation of that conduct which made court staff.
What did Mr. Freeman do in the courthouse that justifies this order, that in your view justifies this order banning him from the courthouse?
It's a conduct where it's coming into the front gate, and it's just right off the top of my head, it's just a course of conduct that he and others have conducted, how they've conducted themselves in the court in violation of the judge's orders or doing things with a bailiff. So that was the conduct coming up to the final thing where he was harassing. I've been harassing the staff outside of the courthouse.
But forget about what other people did. Just talking now about Mr. Freeman, and I'll ask you in a minute about my other client. But starting this with Mr. Freeman, what did Mr. Freeman do in the courthouse that justified, in your mind, banning him from the courthouse? And I'm not talking about course of conduct, I'm talking about specific acts or specific things.
I don't remember exactly what, it's been a period of 3 years that we've been dealing with Mr. Bernard in the court, and there's always been something that was going on either with the bailiffs or the staff or whatever. So it's a period of time of 3 years that I'm aware of it, that we've been dealing with him, and this last thing being what happened at the court that day, first day.
So you said it's been over a course of 3 years, and you're not able to recall a single improper act or a single improper statement?
The acts, right at the top of my head, I cannot remember what everything that happened with him, other than we know that there's been an issue in the past.
Sir, do you agree, you're the chief law enforcement officer for this county, is that correct?
That's correct.
Do you agree that Mr. Freeman had a constitutionally protected right to monitor court proceedings in Superior Courthouse?
I believe the question was, do you believe
believe he had a constitutional right.
Does he agree that Mr. Freeman has a constitutionally protected right to monitor judicial proceedings in the Superior Courthouse?
I'm going to object, Your Honor. The sheriff is not an attorney and is not a witness who is best able to answer a question involving constitutional law.
Your Honor, if I could respond to that, I think it's normally true that you wouldn't ask a non-lawyer questions of law, but in this particular case, where we're dealing with a gentleman who's identified himself as the chief law enforcement officer for Cheshire County, and whose duties, I assume, would include the protection of constitutional rights, it seems to me it is a reasonable question to ask him whether he understands.
I think it's a reasonable question to ask. However, I'm going to take it. It's ultimately up to me to make that decision. That's
Well,
what
that's right. I simply find to understand, and I'm not trying to pursue it. I'm asking that question whether he understands or agrees, whether he agrees that Mr. Freeman has a constitutionally protected right. Any New Hampshire citizen has a constitutionally protected right to monitor judicial proceedings in Superior Courthouse.
Your Honor, before he answers, the state would like, and this is just almost a minor point, but the state would argue that actually the sheriff is probably not the chief law enforcement officer of the county. That would probably be the county attorney, just as an attorney general in the state is viewed as the chief law enforcement officer in the
We
state.
know that the sheriff is higher up than most people in the county law enforcement.
That is
If he's not
correct.
number one, he's number two.
That is correct, but again, the state would argue that his familiarity with constitutional law.
And I think the question's appropriate, but I'm just gonna, the weight I accord it is gonna be, based on to the extent to which he thinks he can competently answer the questions. Ultimately, that's what we hear from you to decide when I hear all the evidence.
Very good, thank you, Your Honor.
After that, James, do you still recall the question? You won't repeat it.
Repeat the question.
Sir, do you agree that Mr. Freeman and indeed all other citizens of the state have a constitutionally protected right to monitor judicial proceedings taking place in the Cheshire County Superior Courthouse?
As governed by the judge, yes.
Well, does the judge have the right to breach the Constitution?
The judge has, if I'm in charge of the security of the courthouse, and the judge has specific orders, and whatever those orders come down for any particular day or court case, those are the orders that are followed by my bailiffs and my deputies. And there are procedures that the court requires, and we assist in making sure that those procedures are just like they are here. So
But it's your understanding that you're aware that Mr. Freeman had a practice of monitoring judicial proceedings?
I assume when you're talking about Mr. Freeman, you're talking about your client.
I am.
Okay.
And
Just for accurate, does your client officially change his name yet, or is it still?
Your Honor, it's my position, based on New Hampshire Supreme Court, that your name is a name you choose to use.
Unless
And it's not necessary to...
Well, my understanding from the original arraignment is that Mr. Freeman said that he was there to pursue probate court for a name change. I didn't know if that was...
I think that's correct, Your Honor. At least it's my understanding. You don't need to go to probate court to change your name. I think that the common law of the state...
Well, maybe I'm just anticipating a factor in this case, but I know the setting for their presence on the occasion here, which I learned from the arraignment, was that he was there to pursue that issue.
Well...
But the point is that we have... The point here, Mr. Martin, is that we have his name on... appears one way in one pleading, one way in another pleading, and we need to have some
I think that's true the other defendant too. But beyond, just to make our positions clear, it's true that Mr. Freeman was pursuing, as I understand it, a probate court proceeding to change his name, even though my opinion that's entirely unnecessary. But I'm not arguing that's the basis for him being in court, because it's our position that his role in monitoring judicial proceedings.
I'm just looking for consistency in the record and in all the records here. And the record is not consistent, that's all.
In any event, yes, sir, when I use Mr. Friedman, I'm also referring to Mr. Bernard. And the question was, are you aware that he has engaged in monitoring of judicial proceedings over the past 3 years?
Yes.
And that that is a constitutionally protected course of conduct?
Yes. But that's also governed by the spirit of the
Right.
judge.
But is there anything that he's engaged in while engaging in that conduct? Is there anything he's done that's violated the constitutional protection that he's entitled to doing that?
Well, we've had instances where he's left his camera on in the courtroom, in the courthouse when he wasn't supposed to. And we've had to tell him to take it off, even though he knows full well coming in there what the judge's orders were not to do that. So, yes, he has violated the orders as prescribed by the judge,
But he's doing something that's constitutionally protected.
against the orders of the judge.
Well, the monitoring itself is constitutionally protected.
Your Honor. Again, I'm going to stop it here, we're going too far with it. The issue is going to be up to me. I mean, the time, place, and manner of an exercise of a right, it's not an infinite right. I think we would agree on that. The question is we're going to take these facts in this case and decide what to apply the law and the Constitution and see where we come out. So,
Thank you, Your Honor. Sir, prior to issuing the banning order to Mr. Friedman, did you give him any opportunity to present his point of view?
Not specifically, no.
Did you have any type of conversation with Mr. Friedman prior to issuing the order, about the order?
No, not when I issued the order.
Sir, you have in front of you a copy of the order itself, correct?
Yes, I did, yes.
Now, the second paragraph says, if you have any legitimate county business that requires you to enter and remain in the Cheshire County Superior Court building, you are to contact me to make an appointment to conduct your county business. What does legitimate county business mean?
Whatever reason he has to be there.
So anything he wants to do in the court is legitimate county
Absolutely.
business. So if he wants to go into, if he wants to go to the courtroom and if he wants to go to court and watch judicial proceedings, that's legitimate county business.
Everything that he has to do in the courthouse is legitimate business.
So now, am I correct that this order says you are prohibited from entering or remaining on the county property?
Without getting permission to do that. For any purpose.
All right, so, who's the person entitled to require to give permission?
Any one of my staff can do that. They've done that.
Was that what this order says?
The orders for Mr. Bernard and others, and the internal order is that any one of my staff, because most of the phone calls that come into the sheriff's office are for the sheriff, and they pertain to other purposes that the deputies do. If somebody calls asking for me, the staff, probably as your staff may, looking for what the purpose of the call is, and 9 times out of 10, probably 99 times out of 100, somebody else will take care of the issue as they do with these.
Sir, you said they're internal orders. Are those internal orders in writing?
No.
Where are those internal orders?
I've given them to the I've given them to the deputies.
So you have told them that any deputy can essentially respond to a request for permission to enter the county courthouse.
That's correct.
So what criteria are deputies supposed to utilize in order to decide whether or not to permit entry into the courthouse?
The illegitimate purpose, and that's for anything.
So if any legitimate purpose is anything, is that right?
Anything legitimate purpose, that's correct.
So essentially, if Mr. Freeman were to call your office, he wouldn't need to speak to you. He could speak to essentially any deputy in the office, and any reason he gave for going to the courthouse would be considered a proper reason.
Yes.
And so the deputy at that point would be authorized to tell Mr. Freeman, okay, you can enter the building,
Yes.
or go into the parking lot.
Yes.
And are any of these instructions or criteria in writing?
As I said, no, they're not.
And how would you communicate these instructions to the other? How many other deputies are there?
There are 9 deputies and then there's me.
And how do you communicate them?
I told them.
Individually or in a meeting?
If they weren't all at the meeting, could have been both.
So if Mr. Freeman had called your office and said, I want to go to the courthouse parking lot for the purpose of videotaping court personnel, your deputies would have been instructed to say to him, fine. Is that right?
Yes.
So there's nothing that Mr. Freeman did prior to issuing this order that he couldn't do after issuing this order.
That's correct.
So basically, this order isn't worth the piece of paper it's written on.
That's not correct.
All right, well, what is the purpose of this order if it simply requires my client and other people receiving this order to call your office where they can talk to anybody and get automatic approval? What does it accomplish?
It accomplishes that we know that he's going to be there, and it eases the bailiffs and the court staff. So we know he's going to be in the courthouse because of his prior history in the parking lot in the courthouse. We know he's going to be there. And that's basically what it's for, is that if he's going to come into the courthouse, or any one of the other individuals coming into the courthouse, the purpose is for us to know they're in the courthouse. That's basically the purpose of the order.
Now, you could have drafted an order to Mr. Freeman saying, please call us before you go to the courthouse, correct?
That's basically what that says.
That's basically what it says. And it also, but this also says you are prohibited from entering or remaining on the county property of 12 Winter Street in Keene.
Yes.
Did you mean that?
Along with the last paragraph, yes.
Did you mean to prohibit him from entering or remaining on the county property of 12 Winter Street in Keene?
Without permission, without us knowing it.
But you're saying permission's automatic. Is that permission?
The permission is because the permission is an internal thing, and you're taking one part of the order that's totally changed by the last paragraph. It says if he calls, he can come in.
Well, this is titled no trespassing order.
That's what it is.
What sort of no trespassing order is it when you intend to give free access to the person receiving the order?
Your Honor, the state would object to this being argumentative.
I would thought that question, Your Honor. I think that's correct. So, from your perspective, the only purpose of this no trespass order is to give court personnel peace of mind that they would know in advance when Mr. Bernard or anybody else subject to this order is going to be in the courthouse?
That's basically what it is.
Now, to understand the Superior Court process a little better, am I correct in understanding you can't just walk in the door anyway? You have to present yourself to one of your deputies
Yeah, yeah.
and go through a search process, et cetera, et cetera. And
Correct.
at that point, presumably your bailiff or your deputies could notify all their personnel that Mr. Freeman or anybody else is present, correct?
If they're able to do that.
Why can't they be able to do that?
Because there are other people there, and somebody has to take the time to get on the phone to do that. And we've also had instances where we've had people that, I don't remember whether Mr. Bernard or not, but others, there may have been somebody, one of those 5, that we've had go through and breach the security, where they've had to be wrestled down in front of the security there.
Well,
So,
wait, I'm talking about Mr. Freeman for a minute here.
well, no, the question was whether or not bailiff would be able to notify other people in the court, and I'm saying that that's not necessarily possible because of the other people being there in the screening process. If we know they're going to come in, we could have 2 people there. But so with one person there, they can't necessarily stop and make a phone call to let everybody know that any individual is going to be in the courthouse. So it's not, they're busy, it's not an instantaneous thing that can happen.
Doesn't, what type of communication system do the bailiffs have with other court personnel?
They have to other court personnel, they have a telephone.
I mean, they could have the cell phone or they go to regular?
They have a phone, a regular phone. There's 2 phones actually right there by the bailiff station.
No walkie-talkies or anything like that?
Amongst their own people, they can do with that, doesn't notify the court staff.
Well, but I mean, surely the bailiffs surely have means of communicating to other court personnel without using telephones, isn't that correct?
The other the only people that they have access to talk to are the other bailiffs by radio, and to my people downstairs in the sheriff's office.
So they could certainly, when Mr. Friedman arrives, if they thought it necessary, they could certainly radio to your people and tell them Mr. Friedman has arrived, correct?
That's not, they could do that if there's somebody there, yes. We're busy also.
Well, but you might be less busy if your office didn't have to answer phone calls every time Mr. Friedman or somebody else wanted to.
All right.
Objection, Your Honor.
Sustained.
Thank you. So you've got a copy of your order in front of you.
And
Wouldn't a reasonable person receiving this order interpret it to mean that they couldn't enter the courthouse instead of their own court appearances? Isn't how that would be reasonably interpreted, isn't it drafted for that purpose?
No, it's not.
You say, wouldn't a reasonable person
Person
think
had
that?
interpreted this to mean that they couldn't enter the courthouse except for their own court appearances.
And the answer was no?
No,
I didn't get the end of his question.
the answer is that reading the order, they can enter the courthouse if they call.
They can enter the courthouse?
If they call.
They call. And is there any reason you didn't put into this letter to Mr. Friedman a statement, you can enter the courthouse after you call?
You just said that's what it says, it's a call for permission.
Is that what it says? You have it in front of you.
Make it a point to conduct your county business, so.
Now, so you said you got this trespass order from something that was used by other county employees for the purpose of other county buildings?
Yes.
And who did you get it from?
I'm not sure where it came from. It might have been sent to me by email from somebody. I don't remember where it came from.
And was it your understanding that the purpose of this order is simply that it doesn't really mean no trespass, it simply means call first?
For the purpose of the order for us, the reason that, because that's what the order is no trespass order. And it's the same, it was used for other county buildings such as the nursing home at 33 West Street, so that people were coming and creating a disturbance would be told to leave, and then if they had to come back to visit a loved one in the nursing home or whatever, they could call so people at the nursing home would know that they were coming.
How long was this order intended to last?
There wasn't a time, it was based on the conduct of the people who were involved. If conduct was proper and they followed the rule, it was no It's just so that they understood it's a temporary basis to be done based on their conduct and how they treated themselves in accordance with the order.
When you say temporary basis, is there anything in this order indicating it's temporary?
No.
Isn't it fair to say that you communicated to the individuals covered by this order that the order was intended forever?
I don't know I said that.
Did you say that?
I don't believe I said that.
Was it your intent that this order go on forever?
No.
How long was the order intended?
The order was, as I just stated, it was depending on their conduct and how when they came into the courthouse, how the conduct was and how things went. If everything was, conduct was proper and we had no problems, then there's no reason why the order couldn't be received.
Now, in Mr. Bernard's case, Mr. Friedman's case, you're aware that he argued in his defense on this case that he called your office on the day he came in and did not get left a message.
I don't know that.
You're not aware of that. Do you know whether he called your office on that day?
I don't know. I don't remember the date that this happened. But if he'd called and told somebody what he wanted, he would have been given permission to come in.
So anybody, not even a deputy, even a receptionist?
No, it was clear in my previous testimony that the deputies are the ones that make that decision.
Now, sir, you're familiar with a woman with the name of Lynn Sarevsky?
Yes.
Yes. And I want to ask you, because I'm also representing her in this proceeding, what acts, if any, did she commit that you allege justify this order?
She was part of the 5 that were creating the disturbance.
No, what did she do?
As being one of the members that were doing the same thing.
Well, what is it she did? We're talking here now about a criminal prosecution, not about group liability. What did she do?
She came as part of the group, and that's what is part of there can be a group liability, she being a member and conducting herself in the same manner. She may not have had a camera, but she was there with the group conducting themselves in that manner that caused the disturbance or the problems with the support staff.
So she was part of a group, and that's the sole basis?
No, the sole basis, as I just said, was the conduct of those people. She was one of them and going with them.
Well,
and the conduct was interfering with or coming and interacting, what I saw harassing, in my opinion, harassing the court staff as they were leaving.
Okay, well, what did she do that was harassing?
She was one of the others, the same, getting close by, and she didn't have a camera to stick in someone's face, but she was part of that group.
Did you specifically see her get close by?
She was there with them, so yes.
Saw it? Is that a yes or no?
Yes, she was part of.
So she got too
I
close?
don't know that she got within 6 inches of anybody, but she was part of the group that was creating the disturbance where they were yelling at the staff and creating the aura of fear amongst the people and staff.
How close did she get to the staff?
I don't remember. I'm looking at a camera, so it was a course of conduct that caused that problem. She was part of that course of conduct.
So whether she individually got too close to any staff member or not, you don't know?
I can't, no.
But your overall reason for this no trespass order was because, in your view, this group of approximately 5 individuals got too close to court personnel in the Superior Courthouse parking lot, and some of these individuals had video cameras.
That's simplification. It's a course of conduct where they're yelling and the recording the people, their license plate numbers, them, the whole course of conduct that put them in fear of confrontation with 5 people and in the normal course of their business as they were attempting to go home.
All right, but take any one of those incidents, the allegedly getting too close, using a video camera, the filming of license plates. How are any of those affected by this no trespass order?
Well, they can go, the issue is that they want to stay, and actually came back at the next day, and that's how they got issued the order. They came back and stood on the sidewalk and to do the same thing. We just gave them the order. There was nothing wrong with them, and they knew they could do that. That was the issue. The issue was being in close proximity to the staff so that they felt that they were threatened or being harassed by them.
Right. But how is that problem addressed by issuing them a generic no trespass order, which is basically simply saying call first? How would it be any different if they called your office before they went to the parking lot? I mean,
After
your
the
people
order?
are right there anyway. It's not like you have to travel 20 miles to the scene of the event. How does this no trespass order accomplish any of the, or address any of the concerns that you've outlined?
The no trespass order lets us know they're coming, and we can be there as necessary so the court staff can move freely to their car and without being threatened by the group.
Oh,
And the court staff will know that they're there. What, the last day when they were finally driven off the property, they were waiting in a parking lot and waited for the staff to come out, and then they came over after.
right. But where's the sheriff's office located?
Downstairs?
In the Superior Courthouse?
Yes.
How far from the parking lot?
It's in the adjacent to the parking.
So you don't need an advanced phone call or coming to the parking lot in order to provide, if you feel you need to provide more security in the parking lot, you can certainly do without this type of order.
No, because there may not be anybody there. It's very, very feasible that if there's no prisoners in, and this is happening after work, if there are no prisoners downstairs when there's liable to the deputies have a lot of other things to do. If they don't need to be in that office, they're not in the office.
Over there in the building.
No,
You have 9 deputies.
that's correct.
And yourself. If there is a need for people, if you felt there was a need for people in the parking lot, you put people in the parking lot, correct?
Yes.
And if an illegal act is engaged in the parking lot, you can arrest somebody in the parking lot, correct?
Yes.
Have any of these individuals ever been arrested for doing anything illegal in the parking lot?
I don't think either one of these two have.
Can I have a second, please?
Yes. Is that going well over there? You get a taste?
Sir, you made an assertion in your earlier testimony that Mr. Freeman was arrested in the Superior Courthouse prior to the banning order being issued for some other activity.
I believe so. That may not, I didn't do it, so.
So are you saying that based on, what are you saying that based on?
The number of people that we've had that associated with this group that have been arrested in the courthouse.
The fact that other people have been arrested in the courthouse doesn't mean.
That's correct.
Now, You keep on referencing this group. If other individuals had come to the court parking lot and engaged in the same activity, i.e. expressing themselves or using a videotape for personnel, would you still issue the banning order, or was the banning order based upon the fact that these individuals were members of the group at the same time?
So the term group is identifying 5 people as being those 5 people. That's what it is. They were there, those were the 5 people. That's the group. That 5. It's got nothing to do. If anybody else came, 5 or 6 people came, another group came in, whatever their purpose would be, and created the same disturbance and ended up with the same order, I would refer to them as a group.
But some of the individuals, these 5 individuals who were there in the parking lot, some of them had never been to the parking lot before, correct?
I have no idea.
So you've seen Mr. Freeman there before, correct?
Yes,
But there are other individuals you issued a banning order to who had never been to the parking lot before in their lives.
I have no idea.
See, anyway, you didn't necessarily know that it wasn't a condition of receiving this banning order that the individual was in the parking lot before.
Other than the previous days, yes, they were repeat from when the incident started. They were there until the final order was given. So they had been there before that day when the order was given. The verbal order.
Why didn't you just give them an order saying keep out of the parking lot?
I did.
No, but you could have given them a written order saying keep out of the parking lot. You didn't have to say a written order saying stay out of the courthouse.
Could have done either. The courthouse is just it's the whole thing. It's just, it's a history that we've had in there, and that was just included in it, so we know that they're coming into the courthouse.
And what are you going to do differently if you know they're coming into the courthouse?
If they say they're coming in, then we're just aware of it, and depending on, if necessary, we notify the bailiffs are coming in, and know where they are in the courthouse, that's all.
Well, first of all, it might be that your answer is you're not going to do anything differently if you know they're coming to the courthouse.
Other than the notifications, and depending, if they're there for a court case or whether there are other people coming, depending on what's going on that day, we're going to adjust to cover whatever we need to do. So it's an evaluation we make on a day-to-day basis as to what's going on. So if they're coming, we know they're coming, and we just adjust there.
Well, you've got a certain amount of staff to cover the court building no matter what, correct?
Yes, and bailiffs.
I think we're going over the same ground again. Is there a new point?
No, I'll not proceed. So, sir, is it fair to say that the order that you gave to my clients is not intended as an order for them not to enter the courthouse, but is intended just as an order for them to notify your office before they enter the courthouse? Is that a fair summary of your position?
Of my position, that's correct.
Thank you.
Thank you, Counsel.
Yes, thank you, Your Honor. First, Sheriff, you just indicated that by having this no trespass order and the requirement that you be notified, you, meaning the Sheriff's Department, be notified.
Actually, I'm just going to stand off to the side here, stretch my... Go ahead.
Be notified. You indicated that that would allow you to adjust your personnel assignments, is that correct?
Yes.
And under ordinary circumstances, how many deputies might you have at the courthouse at any particular time? Is there any, I mean,
Depends on what I need. They come and go as they need to for their normal business, and if I need somebody to be there, then they adjust their business to take care of the needs we have at the courthouse. I've actually called deputies from other counties to come in to help when I needed to do that.
are there many instances where there might not be any sheriff's deputies at the courthouse and only bailiffs?
Yes.
And would it be fair to say that by requiring the notice, that would allow you to assure that there were at least some deputies there to assist the bailiffs should it be needed?
No, I guess these are leading questions, even though it's a cross-examination to essentially the state's witness.
It is cross, Your Honor, and
Overruled, go ahead.
Thank you.
Could you repeat the question?
Would it be fair to say that by requiring notice, it allowed you to arrange your staffing in such a way that there would definitely be some deputies available should the bailiffs need assistance?
Yes, we can adjust our staff.
As sheriff, are you responsible for court safety?
And security, yes.
For court safety and security. And were there any actions committed by both defendants, Mr. Bernard and Ms. Saratsky, that in your opinion affected court safety and security?
No, I would simply request that rather than lumping the two, I don't mind the question lumping the two together, but I would request that the answer for clarification of the record, clarity of the record, that the two individuals not be treated as one entity, but that the answer address each separately.
The state will rephrase the question, Your Honor. As the person responsible for court safety and security, were any actions committed by the defendant, Ian Bernard, that, in your opinion, affected court safety and security and that led to your serving the no trespass order?
Yes.
And what were those acts?
Particularly confronting the judge when he left his chambers to go to his car with the group of, I don't know whether all five of them came specifically to him, but coming to him with the camera and surrounding him as he was trying to get in his car.
Do you know whether judges' license plates were videotaped by the defendant, by Mr. Bernard?
I don't know.
And did you receive any requests from the judges for coverage when they left the building?
Yes.
And what actions were they concerned with?
The actions we
Well,
received.
wait. I think that the state of mind of the people who asked him is really beyond this witness's testimony. I don't have any problem with him testifying as to what actions he requested to take, but not about what their concerns were.
So you have any response to the objection?
Yeah, well, the state believes, Your Honor, that as the defense is...
The question you asked was what were the judge's concerns, and the objection was that the state of mind of the judges is not important.
And the state would say that doesn't...
Well, I shouldn't say not important, I think was it not relevant?
Right. It's not that it's not important. Well, it's not that the ground is not so much importance and relevance as hearsay and lack of foundation. that the judges presumably could come in if they wanted to and testify to their concerns, but this witness is not in a position to give, I mean,
Yeah, on the hearsay, I thought it was hearsay, so.
yeah, hearsay.
It's, the state will rephrase the question. Did you observe any actions directed towards the judges that impacted your concerns regarding court safety and security?
When the judge left the side building, the side door of the courthouse to go to his car, the judge that was on duty that day to go to his car, the fact that he was going to his car and there were people that were coming toward him to his car certainly created a concern on my part that what their purpose was, and sent deputies out for that, and then it occurred again the next day the same way. And we sent somebody out with the judge and went out so that to keep them back from so he'd be safe.
I believe you testified that that among the actions that led to the issuing of this order was videotaping of license plates of court staff. Is that correct?
Yes.
And again, based on your responsibility for court safety and security, did that impact your decision, and that how did that concern you from a safety and perspective?
The concern was that they were identifying the individuals, the people that work in the court with that particular car. So then it was an identifiable thing, and they were there doing that as a person was trying to get into the car. So there were a bunch of issues there.
And specifically, how might that have affected court safety and security?
That there would be known that these, there were actions against the court staff, and that would just help identify them and be able to recognize the car later that who the car belonged to.
Isn't that what it is?
The defense refers to the no trespass order, and they repeatedly refer to it as a banning order. And while this may be more semantics, but was anybody ever banned after they contacted your office and requested permission to enter the property?
No.
And just to clarify, if Mr. Bernard had been asked, had contacted your office and said, I want to come to the courthouse and I want to attend a hearing, the hearing of John Jones, I'm just interested in it. Would he have been given permission to enter the courthouse and go to that hearing?
Yes.
So from your intent on this order, and in fact in the way you enforced this order, there was never any, was there ever any intent that it had to be a legal matter in which the defendant was personally involved?
No.
And did that also apply to the defendant, Lynn Sarasky?
Yes.
Is it your, as sheriff, strike that. Earlier in your testimony, in response to a question, you indicated that you may not have been, you weren't sure as to whether there may have been a report issued on the incident that, if they understood correctly, that led to the instant charge of criminal trespass. You indicated you were not sure. Is it, as sheriff, is it part of your normal course of events to read personally every report drafted by one of your deputies?
No.
What is the procedure within the sheriff's department regarding approval of reports?
I have a lieutenant that reads and approves the reports and make sure that they're done correctly. If I need to, I can go on computer and pull the report up and read it, but in the normal course of business, I do not.
Okay. And if you were, as sheriff, do you have a lot of administrative responsibilities?
Yes.
And if you were required to read every report written by your deputies, would you be able to complete all your administrative responsibilities as well?
Probably within a course of time.
In a timely manner?
I don't know. It's just not something that I do. It's my call, and I don't have any need to review all the reports that go to the sheriff's office.
Any say something further?
Any regret?
Sir, you made reference to a concern that Mr. Freeman and other individuals had come up to a judge, Superior Court judge in the parking lot with a camera. Now, how would your no trespass order, you interpreted, how would that have in any way affected that?
Well, the issue is the judge is getting into his car, and I have a number of people that are coming toward him, and that's a concern for me, because that's a concern for the safety of the judge, because I don't know what their intentions are. And if they wanted to they could take film from either one of the sidewalks. It was actually one of them they could see the judge's car from. So they're far enough away, and there's a lack of threat of 5 people or whatever people coming to the judge as he's trying to get into his car. That's a security issue as far as I'm concerned.
But were there any, my question wasn't whether it was a security issue. My question was, how would if your banning order had been in effect at the time, or your no trespass order, how would that have been, how would anything be different?
They wouldn't have been able to come to if they'd got permission to be there, then we would have known they were there and taken whatever action we needed before the judge came out, which I eventually did anyway, the second time around, and the third.
Taking any action, meaning?
Protecting the judge from people that are coming approaching him as he's trying to get in his car.
So, but were there any sheriff's personnel present during this situation?
They came up, yes,
They were there anyway, right?
but they weren't there with the judge. It takes a very little time to hurt somebody.
Nobody's ever been hurt or
No,
threatened to be hurt,
I'm
right?
looking at it from my perspective. It takes a very little time for somebody to be hurt if there's nobody there to protect them.
Now, you also, when in your cross-examination about videotaping the staff license plates, how would your no trespass order have any effect on that?
Other than they're right there taking and seeing which person gets into what car and seeing what's in the car. Just a lot of the security issues with that they can be up there and with the person that's working in the court getting into that car.
Right. But if in fact, permission to be on court premises is automatic, as you claim it is, then it wouldn't matter if you go and videotape the license plates whether or not an order was in effect, correct?
It's not automatic, and the point is that it's automatic, but we would know the purpose of the order is so that we know that they're there, and then the staff leaves. If they're giving their purpose for being there in the parking lot of the court, then my staff can be there to make sure that the court staff can get to their car without any problem.
Right. But the issue is not the court staff getting to the car, the issue was your concern was the videotaping of license plates.
That's which is concerned with the security of the court.
Right. But that's not something that in any way is affected by your no trespass order, correct?
Yeah, they can't, without the order prevents them from coming in without our knowledge to be there, and we can, if we know they're going to be there, we can interfere with them in the court staff,
Interfere with them?
meaning keep them from interacting with the court staff.
Would you have prevented them from videotaping a license plate?
Probably not.
So they would have done it anyway, correct?
But it's the element of fear that comes from the people that are there, close proximity to the staff. So they could have done it from the sidewalk. But the issue is that we didn't know that they're on the property, that we know about it, and we can better protect the court staff.
Now, sir, getting just in terms of the notice part that you talked about, you said that your deputies understood that anybody who received permission, anybody who asked, who was subject to the no trespass order, automatically received permission, regardless of the reason they wanted to enter court property. Now, how would that permission be documented?
That they came,
Excuse me?
that they showed up in court. It's
Well, is there some written, does the person then receive some written notice that they are authorized to be in court property?
they're told, we've even done it by phone. That's how it's done frequently, most of the time by phone. We get the request by phone and somebody notifies the bailiff that so-and-so is coming in, and that's the end of it.
Well, is the deputy sheriff then required to notify the bailiff?
He does, yes, and they do.
Well, has that ever in fact happened?
Here's whatever happened.
Has the bailiff ever been notified of somebody receiving a no trespass order entering the courthouse with permission?
If they've been given permission to come in, then the bailiff's been notified.
But is this-
I have not done it.
Has anybody ever done it? Has it ever happened?
You'd have to ask the people that gave the order. That's the procedure, and I'm sure that the procedure's been followed.
Well, you don't know if the situation has ever arisen, do you?
I know that the procedure is followed. If there's an instant that it wasn't, then
Well, Mr. Freeman, hypothetically, calls your office, gets your approval to go to the courthouse, enters the courthouse, you're saying that you notify the bailiff. But how do other court security staff, other deputy sheriffs know he's there with permission?
because the bailiff let them in. And frequently when they're no, and if he comes in the building.
Your Honor, these questions are going beyond the scope of new information that was brought up on cross. And
state believes that these questions have actually been touched on previously in the defendant's direct examination.
Your Honor, I don't have any need to ask any further questions on the subject matter.
Okay, anything else?
Nothing further.
Just a couple questions, Sheriff. I'm just assuming when safety and security are intermingled concepts, you don't make different decisions for safety, different decisions for security. They just sort of, it's just a phrase.
Yes.
And you're saying that it's not possible that, for example, if I were one of the 5 persons notified in the order, and I called up and got one of your deputies and said, I want to go to the parking lot because I want to tape employees' license plates. I want to videotape. You're saying that would not have been denied.
That's never happened, but probably not, as long as they're not interfering with the,
I guess my question is,
because that's something to do
I guess
outside.
what's the possibility that one person of the 5 listed could have called and gotten one deputy who would have granted permission to enter the property for a particular reason, and another person got a different deputy and got a different answer? Said, no, that's not a legitimate purpose. Is that a possibility?
No. It would be, discussion.
So you're saying that just the simple act of asking the question, of asking for permission, is an across the board. The answer is going to be yes every time.
Unless they came to say that they're going to come to solve the
Well,
job.
I understand, obviously.
So if it's for legitimate purposes,
Well, so I guess that's what I'm getting at. I mean, for legitimate purposes, is it possible that one deputy might interpret a request as legitimate, and another deputy might interpret it not as legitimate, and they might be on a different phone at the same time?
no, that's legitimate purposes, whatever they're coming in for, other than some sort of, extreme thing as I described.
All right, based on my question, do you have anything, Mr. Meyer?
I have no further questions.
Okay.
Nothing further.
Okay, thank you very much. I guess there's still a sequestration order. Can the sheriff go back to work, or do you need to stick around?
I'm fine, Your Honor.
And secondly, as far as the trespass order, it was referred to, but I've got a copy in one of the pleadings. Is that sufficient for the record, that the trespass order is in the record? For everybody?
Yes, Your Honor.
And the state has no objection to the sheriff being dismissed.
Okay, thank you.
Thank you.
It's 10 to 12. What are we looking at for
Your
procedure?
Honor, I think, Your Honor, I only have basically 2 more witnesses, and I said will be rather brief.
Okay.
And the state has witnesses that are members of the Superior Court clerk's staff, and their testimony will also be relatively brief.
So I'm willing to just keep going. I'll take a 5-minute recess and then...
State has no objection, and the state appreciates the first willingness to follow that.
Well, this could just be solved by an apology by Sheriff Foote, apparently. Like, oops, I made a mistake. Yeah, which, we all do that, right? We all make mistakes. Just a little, oops, I overstepped.
Being a bureaucrat, you never have to say you're sorry.
No, I know,
You
but
talked to
I
a
mean-
lawyer before you issued the order. I'm sure you talked to him before today.
You're
And
supportive
the,
of
and
that.
the prosecuting attorney? Oh, God. That's embarrassing. He needs to get a speech therapist. All right, I'm going to go downstairs. I'm going to get some water.
Standing in the hall.
Don't drink my water.
A couple weeks. That's okay. And he came out and, I had a good report. He's one of the better deputies.
And then have 100 days chance that they're that day when pulling someone through the day prior.
I was only there one day.
Yeah, I was there the day prior and the day prior to that. I just happened to not be there that
So
day.
like walking the parking lot and getting cameras, I was there for like 5 minutes and they're like, you're big.
Stealing the city's electricity.
I wasn't there for a day before.
Specifically,
Well, your group.
he said,
It was my group. Like just because I'm standing with people or
he took me
talking
to went inside. The offense was later said that you were
well, that's basically what
coming out
the
at some point.
sheriff
I was
told
still
me
there.
when I called him after
supposed to
he
be
got
working.
arrested.
Yeah, that's what Lance told me, so
You were part of the time.
I was there for $100.
If you weren't there for the group, this would
garage I
be an
actually
issue.
pulled into, pulled in.
Okay, so what did I do?
Days
You were
later,
early
So I pulled
group?
in and I took on the spiral.
I like the phone notification thing where you say, we don't make a record of it, or just call whatever. I said, hey, I had a. And that goes well with, that you can't report a phone call in Canada. He did get it. So you can't have a record of you, he's getting money again.
Yeah, like the whole thing is but you have the jurisdiction to give somebody no trespass. But you don't have the information on what it is.
Asking the relatives if they trespass. The reports on the deputy had done. Like, oh yeah, he would read every random report, whether he does just relatively speaking, changing one of those code with our. I would do that.
Required to no trespass.
My intention was to
share one on place.
Without necessarily asking. I mean, I don't mind, I'm just saying.
I mean,
Probably
you
know how the election turned out?
Right. Is there anything else?
Becky has the claim that I was wrong. We've got to I certainly wasn't in anyone's personal space.
And you were never arrested. Never. Something like that, that's fine.
And I wasn't.
Yeah, no, I didn't.
I like came here at 9 a.m. because I was like, okay, I'll come back to that.
What we do now is Robin has to put a sign on it, that we pay.
But-
Yeah.
I'm wondering.
So wouldn't that be the same?
Yeah, whatever it is. I'm forgetting what trespass is.
The thing about bylaw is you're supposed to be here before it starts, regardless of when your docket gets called.
Yeah, I know.
Every time I, make it sound like it's a permission type scenario, whether that is.
Why did you flip off the election? You did?
Yeah, he's aimed up.
See, Sharon said it looked stupid, didn't it?
And it wasn't meant to be an eternal war.
No.
I'm at a loss.
Oh, it could have been my intention to ask for permission to come in. I never would have known that because I didn't have that.
We could have, one thing I can say that was.
Just call.
Yeah, right.
Just call first. Take that out of order.
Give us a heads up. We're in a line. We can still be live.
Just for the
Harassment.
Did anybody get charged with criminal
harassment?
No. They got this, call us first quarter.
And it's like, in the game now, with this same judge, with the same.
Well, it goes to the overall order. Yeah.
But I don't think, each of these individual constitutions, we can discuss that with the judge.
So what is the actual charge that's being heard?
Violation of the address.
So criminal trespass.
Yes, criminal trespass.
And no, I'm not.
Because you didn't call?
Because deputy tried to call.
What?
Did you call?
They never returned his calls.
Yes.
Can you tell why?
Mike is still here.
Yes. Yes.
Yeah, so I'll check and see which one. I know Anna
never returned
has a
his
sick
calls.
child, or had a sick child, I don't know if she's still caring for it, so, thank you.
But 3 other people got arrested that day?
So,
There's a possibility that at the time, the
one,
intention to just do one call.
there's one deputy or?
And let him do the rest.
Well, that's why I asked if he gave his name and told why he was.
Yeah.
No,
So that it would be on our phone.
But I think it's everything, once it gets to court, and legal, and needs to get tied up, Oh, it was never meant to be voted on trespass.
I shouldn't need to testify for why I wanted to talk to him. We had someone call me back.
All the videotape shows
Yeah, 6 inches.
Nobody got
It forms a basis for
less than 4 feet.
All rise.
Your Honor, I
Came out without warning, David, so.
Oh, I'm sorry, Your Honor. Your Honor, I've agreed at the county's request to permit out of order for the convenience of witnesses,
Okay.
2 witnesses. This one issue I want to raise, so we don't have to keep on objecting. It's my position that the only pertinent testimony here in terms of alleged disruptive acts or acts committed by 1 of the 2 defendants and not acts committed by other individuals. So, I discussed with David the fact that I think that's relevant. He appears to think that it's relevant, the act of any individual or part of any group or part of this group. And rather than objecting every time, I just want to raise that concern at this point.
The state, Your Honor, believes that the validity of, that the order was based on the actions of collectively of the 5 individuals who were served with the order, of which 2 of those individuals were the defendant and Ms. Saratsky. And based on information and belief, some of the witnesses of the state, were aware of what was going on and the people that were surrounding them, but because they had never really been introduced, they didn't know who specifically, they were, but were familiar with, some knew one, some may have known the other.
I guess a lot of it depends on what the defendant's position is. Is it the defendant's position that their behavior didn't rise to the level to justify the issuance of an otherwise valid order? Or is the argument that the order is just not valid irrespective, no matter what they did or didn't do?
No. It's the former. In other words, I'm not saying, we're not taking a position that under no circumstance could a sheriff ban an individual from a courthouse. I should certainly contemplate circumstances that are so extreme that such an order would be justified. I'm saying in this case, based upon the allegations against the individual defendants, they did not commit any type of act which would justify this type of order. And that the orders themselves are directed to the defendants individually. Prosecutions against them are prosecutions of them individually. Whether they are part of a group or not is legally irrelevant. And I think the standard here should be what they did, not what other individuals may or may not have done.
And you just think it's relevant to support just the overall reasonableness of the order?
That is correct, Your Honor. And also, the state anticipates that the testimony will provide more detail to testimony that has already been admitted by this honorable court through Sheriff Foote.
Well, I think I'm going to allow them to testify, but I think the party's going to have to leave it to me to segregate because I think the overall reasonableness of the issuance of I can't get away from thinking I'm going to have to be thinking about that at some point. But you're going to have to trust me to segregate specific acts of these particular individuals when I assess their cases as individuals.
The state has no objection to that. Okay, thank you. And the state would like to thank the defense for allowing the state to call out of order 2 witnesses. The state would call Anna And for the record, Your Honor, the witnesses from the clerk's office are under a protective order granted by this honorable court that allows them to simply testify using their first name and a general location for
Well,
their
people's address is usually irrelevant anyway. Please raise your right hand. You swear or affirm that anything you say here will be the truth? Have a seat. You've been identified as how do you spell your first name?
A-U-N-A.
Okay.
Good morning. How are you employed?
Virginia County Superior Court.
And as an employee of the Superior Court, during a period of time in late 2012, were you exposed to certain activities when you were entering and leaving, when you were arriving for work and leaving work at the end of the day?
Yes.
And could you, and were these activities conducted by, among other people, the defendant Ian Bernard and Lynn Sarasky?
Yes.
And could you please describe to this honorable court what those activities were?
I never really had to deal with anything that happened in the morning, but it was generally at night when we were leaving. All of us staff members felt like we needed to leave together because they were out back singing Christmas carols and waiting for us to come out with video cameras. They weren't necessarily like coming at us, but they were standing along the side of us. So we felt that we all would walk out as a group so that we didn't get individualized.
Were these, you say, singing Christmas carols?
Yep.
Were these traditional Christmas carols?
Traditional sound-wise, but change in words.
And what were the words, what message were the words conveying?
If I remember correctly, it was in regards to an incident that had to do with one of the bailiffs. And so his name was being brought into the Christmas carols.
And were questions being asked to you as you were leaving the building?
Yep.
And do you recall what some of those questions were? Do you recall whether the defendant, Ian Bernard, asked you any questions specifically?
It wasn't directed at me per se, but it was directed towards the group, which it was like, how do you know me?
Of which you were a part?
Yes,
Correct.
yes.
Okay. And,
How does it make you feel to have someone like Bob working for you after his behaviors, basically? I mean, that were exact words, but that was...
what tone of voice was it asked in?
It was in a, I would consider it like a harassing voice.
And did anybody respond?
No.
And how long did this last?
Basically from the back of the building where we exit to our vehicles.
Okay, I'm sorry. For what time frame did this last? I mean, did it last days? Did it last weeks?
At least a couple of days that I remember specifically. There was a couple of mornings that I avoided because I don't get to work until 8. Other staff gets there at 7:30. So they would call and say, don't park in your usual spot, park somewhere else. So there was a couple of occasions that I avoided, situations with them.
Were there any efforts by anybody to attempt to look in windows of the courthouse and If so, was any, what means was used?
I do remember at one point, somebody was flying a helicopter that had a video camera on it. And it was flown up into the second story floor.
And when you say, was this a remote model?
It was a remote
helicopter? Okay.
And I do remember watching the video online after.
Okay. And how did it make you feel seeing, seeing videos put online and knowing that the videos that were being taken of you in the parking lot? How did that make you feel?
I didn't care for it. There's no reason for us to be put on the internet. We're doing our jobs. There's no reason for, the harassment. I mean, I don't necessarily feel like they would physically do anything to us, but just the fact that they're out back with the video cameras, taping us, asking us questions, directing comments towards us, that's harassing to me. It makes me feel uncomfortable. I don't like it. So, and especially I don't like being put on the internet, obviously.
Were you concerned for your well-being?
I was not concerned physically. I didn't think physically, there was going to be any issues, but, to what extent was it going to stop? I mean, is it going to be one of those things where I go to the grocery store and I see him and I'm going to have to deal with it there, or, it's just frustrating. It's frustrating, and it scares me too, because I'm not a confrontational person. So when somebody's coming at me with video cameras and because of something that happened in another part of the building that has nothing to do with us,
So you felt scared by these incidents?
I did. It's unnerving. It's unnerving. I mean, I think it's uncalled for, the fact that we all felt like we had to walk out as a group, to not be individualized. That's not fair. We're all there to do our jobs, get a paycheck, go home and feed our families. We're not lawyers. We're not the judge. We're there to do our jobs. And so for us to be brought into this is very unfair.
Thank you.
You're welcome.
Thank you for coming. I have no questions.
Thank you. You're still on a sequestration order, so you can't share your testimony with anybody until we're all not the case. But you can go back to work, I assume?
Say there's no objection to it.
Thank you.
And then you have a witness or two after that?
Yes,
Stand for a moment. Please raise your right hand. You swear or affirm anything you say you're going to be the truth?
Yes.
Let's see. What's your first name?
Jessica?
Go ahead.
Thank you, Your Honor. Good morning. Could you please indicate to the court how you're employed, where you're employed?
I'm a clerk at Trespass.
Thank you. During the latter part of 2012, do you recall incidents when you were
The
arriving?
latter part of 2012?
2011. Excuse me, Your Honor. Do you recall in the latter part of 2011 incidents when you would be arriving at work and leaving work at the end of the day, where you had contact with the defendant, Ian Bernard, and Lynn Sarasky? And could you tell this honorable court what the nature of that contact was?
It was, I felt that it was harassing questions, intimidating questions, being asked questions about my employer and the people that I work with, being videotaped, taking pictures of my vehicle while we were coming in and out of work.
Do you remember specifically what any of the questions were?
Some of them were in relation to the judge. Some of them were about the bailiffs, some of the bailiffs that we work with. Some of them were in regards to somebody who took their life out in front of the courthouse.
What time did you arrive at work?
I come in at 7:30.
And were they already there?
Yes.
And at that hour, were there usually other people in the parking lot?
Some other employees, but no.
And how did you feel when these actions occurred?
I was worried. I was afraid for my safety. Felt threatened. I was intimidated by them. I was uncomfortable being in their presence outside of the building.
And did you feel the need to leave with everybody else?
Yes,
And why was that?
because we felt safer in numbers. We felt more comfortable having our fellow coworkers together to leave together.
And did they stand in any particular way, for instance, when you were leaving at the end of the day?
It all depended. It varied from day to day. Sometimes they'd be at the bottom of the stairs. Sometimes they'd just be over near our parked cars.
If they were at the bottom of the stairs, did they ever stand in a particular format? Or
Just like a semicircle down at the bottom of the stairs.
And so were you, by their standing in a semicircle, did they part when you tried to go through, when you went to go through?
Yep.
And how close were they to you when you went through?
Depending upon the incident, sometimes they'd be rather close, sometimes they'd be further away.
And how close were they when cameras were directed at you and they would come over to your car?
That also varied depending upon the incident. Sometimes they would be really close and sometimes they'd be across the parking lot.
When you say really close, what's really close?
I would say within 5-6 feet of us.
Do you recall if they sang Christmas carols?
Their own versions of them, yes.
And what do you mean by their own version?
They would change the words to Christmas music to involve whatever incident they were outside about that day.
And how did that make you feel?
Uncomfortable.
And why?
Just because just having them out there harassing us like that is an uncomfortable situation.
And how have things been since the defendants were served with the no trespass order? Do you feel more comfortable?
Yes, I do. It's a lot. We're more comfortable. I'm more comfortable coming in and leaving work. I don't feel intimidated or threatened. There's nobody outside harassing us while we're trying to get to our jobs or leave our jobs. And there actually has been a lot less issues within the building also.
Say something further.
Counsel?
Jessica, my name is Jon Meyer, and I represent. You started off your testimony by saying you were concerned because you were being asked, I think these are your words, intimidating questions. What do you mean by intimidating questions?
I don't recall saying intimidating. I felt intimidated.
By the questions?
Being asked questions and having somebody.
And you say you felt intimidated by the questions. What would the questions were?
So regarding our work, regarding our lawyer, regarding the judge, regarding the bailiffs, regarding working in a place that was against what they believed should be.
Was any type of threat ever addressed to you?
No.
I may have just a moment. Approximately, you described scenarios where you encountered the group of people, sometimes in the parking lot, sometimes in the courthouse. How many times did that happen? All told?
I wouldn't be able to give you a total number. It was multiple times.
Less than 10.
I would say probably more than 10.
Is it true that all occurred in 1 week, in the end of 2011?
Not all incidents that have occurred with.
And is it true that some of those incidents occurred with, or some of those encounters occurred with sheriff's deputies in present?
There was some that they were outside the building.
Thank you. I have no questions.
Okay, you redirect.
No, Your Honor, thank you.
Okay, thank you. Still can't discuss the testimony here, but you're excused and we'll go back to work, I guess.
Yes, thank you, Your
Thank you.
Honor.
How you doing? I'm tired.
Okay, going back to,
Your Honor, the defendant's calls her next witness, Deputy Sheriff Michael Korecki.
you raise your right hand, you swear affirm anything you say you'll be the truth?
Yes, sir, I do.
So, Mr. Korecki, my name is Jon Meyer. I represent the defendant's.
Got an extra battery if that becomes an
State
issue.
for the record.
I'm a lieutenant in the Cheshire County Sheriff's Office.
And does that mean you're essentially third in command for the sheriff's office?
Essentially, yes.
And did you have any involvement in the promulgation of the trespass order?
I had nothing to do with working that order up now.
And how did you find out about it?
I believe I would say probably because of the fact that the order was issued and the people have been in the area that I just heard about it through the office workers.
Did the, were any type of procedures or protocols established to your knowledge regarding this order?
I'm not sure I understand what you mean.
Well, you given a copy of this order?
Yes, I was.
Did anybody ever explain to you how it should apply?
No one explained to me how it should apply.
Let me show you this document, but identify that as being
Just one second.
Is that the order?
That's a copy of the order.
Although it is attached to the plan, you can make this specific.
Objection.
No objection, Your Honor.
Everything okay? Yeah. Oh, okay. Well, you gotta stop recording first.
Never an issue. Basically, the people called me, spoke directly to me, and I just asked them if they were there for a court-related purpose, which is what it said on here. And they said, okay. And I wrote their name down, and then I notified the bailiffs up front that they would be coming in.
When you say court-related purpose, what do you mean by that?
legitimate court business, county business, if they're there for, I guess the terminology is county business. If the people that I spoke to, when they called, they said that they were there to, their friend had a court, they were there for court, and basically just so long, if I knew, I just notified the bailiffs that they were coming.
But what, well, did you notify other court officers or just the bailiff?
The bailiffs are people that are responsible for checking the people in.
But I think you notify the sheriff's deputies, just the bailiff.
If they, no, I didn't.
Did you notify the sheriff?
I'm going to say no, I never did notify the sheriff.
Was any change in staffing ever made based upon somebody on this list calling and saying they wanted to go to the courthouse?
I'm not sure I understand what you mean by change in staff.
Well, was any additional staff added or subtracted or redeployed based on somebody contacting you requesting permission pursuant to this order?
I have no idea. All I did was pass the notification on. If I thought that there would be an issue, I just asked one of the deputies to hang around the office.
Hang around the office?
Yep.
But,
As opposed, I'm sorry.
but we never, okay. Did you ever deploy additional personnel in the courtroom or redeploy them based on this?
Based on this, I myself have never done that.
To your knowledge, has anybody else ever done that?
To my knowledge, no.
Now, in terms of the, again, this legitimate county business, how, does anybody ever explain to you what that meant?
No, they have not.
If somebody said they wanted to go to the courthouse just to observe, would that be legitimate county business?
If they were there to observe a court case, the people that called me, that made mention of that to me, I saw no reason that they couldn't come in, and I said, just so long as I know you're coming in, that's fine.
But what if they just didn't want to observe a particular case, they just wanted to observe court proceedings generally? Would that be okay?
That never happened to me, that never.
But how do you know what was a permissible and impermissible basis for under order?
The only thing that I was going by is legitimate county business. If they were there to observe a case, I consider that to be legitimate county business.
What would be illegitimate? What would be an example of something that would not be permissible?
That was never presented to me during the time that I was talking to the people that called me on the phone.
But did you ever understand what was an example of that?
I never was told that a certain thing would be considered legitimate county business.
Well, what if somebody called you and said they wanted to enter the courthouse parking lot for the purpose of taking license plates, cars parked in that parking lot? Would that be legitimate?
That never occurred, so I guess I'd have to take it on a case-by-case basis.
What criteria would you apply in deciding on a case-by-case basis?
I guess I would determine based on common sense.
But did you, and the sheriff never gave you any direction on this?
No.
So all you know about the enforcement of this order is what you're reading here?
Basically, yes.
And when you granted permission, aside from contacting the bailiff, did you make any sort of documentation?
No, I did not.
Thank you, sir.
Thank you. Any questions for the witness?
Just a few,
You can might have to refer to it again.
Good afternoon, Tim Director. You did indicate that you would ask a deputy to, if you were made aware of a request and had been granted to appear in court, to come into court, that you'd ask a deputy to stay around. Is that a Is that something that would have been out of the ordinary? And what I mean by that is, are there many instances where there are no deputies in the sheriff's office because they are all out doing other tasks?
Yes, it's frequently, there's only one deputy left behind to observe the prisoners in the cell. Because I'm the lieutenant, I do a lot of paperwork, I wind up staying behind frequently. The other 9 deputies will take off and serve papers, transport prisoners, so.
So, in the instances where you knew that permission had been granted to come into the building, does that mean that you would have had, in effect, if they were prisoners there, you obviously need to have one deputy there to observe the prisoners.
Right.
So you would have asked another deputy to stay in case they were needed?
Yes, I just ask them to either stay in the area, be close to the Keene area, or if they have something to do at the office, to not do their papers now, to stay in the office and do a report or whatever, just to stick around the office or stay right in maybe in the Keene area.
Okay. So you did make changes to staffing, to normal staffing procedures?
Well, on certain times, yes, I would.
Okay. Say nothing further.
Sir, my understanding from your response to cross-examination is that you would, if you receive notice somebody's in the courthouse, you would ask one deputy to stay close to the Keene area. Is that right?
There's a lot of things that that go into making that decision. Depending on what kind of case what's happening, how many people are going to be upstairs in the courtroom. I might just ask a deputy. Most of the people here that I work with are friends of mine, so I'd say, you want to just stay in the area. Either that or just do your report here for the time being, and then when you're done, head on out onto the road.
So, I guess that was really anticipating my next question, which was how long were you going to ask them to stay here? And you're saying you'd ask them to stay there for the length of time required to complete the report.
Usually I'd wait until the cases upstairs were completed. They would be, I'd tell them they could finish up or head on out.
Well, you also said that you would ask them to stay close to the Keene area. So if there's nobody in the courthouse, you just say stay, you would call them to come to the courthouse and say stay close to the Keene area?
Just be in the Keene area, so if I needed to call,
Well, with 9 deputies, isn't it likely that you're going to have multiple deputies close to the Keene area?
no. We only have one deputy that serves the Keene area. We have deputies that serve all the rest of the counties, so deputies in Ringe, deputies in, down in Hinsdale, deputies in Walpole, deputies in Nelson.
So all those deputies are stationed in Keene, right?
Right, everybody's stationed out of the sheriff's office.
Right. They may go to Ringe, they may go to Walpole, and they go to...
Correct.
Now, you said you had people, you want someone to stay close to the Keene area. Did you ever call somebody actually come into the courthouse because you were received notice of somebody coming in?
I'm sorry, because I received notice that somebody was, did I ever call anybody in? No.
Thank you.
Mr. Warren?
Before the no trespass order, did you have to, were there instances where you had to have numerous deputies outside?
Yes. And I was actually called in from different locations to come to Keene.
And roughly how frequently did that happen prior to the serving of the trespass order?
I couldn't tell you. I would say I've done it about 3 times before this no trespass order was put into effect.
Nothing further.
Just to follow up on that, you're referring to being called to come to the parking lot?
Come to the sheriff's office, not necessarily to the parking lot, but to respond to the sheriff's office.
For what reason?
because there was disturbance someplace within the building, someplace in the parking lot, someplace out in front of the building. We've had disturbances in the hallways, disturbances in the parking lot.
These were disturbance.
There have been raised voices, there's been some name calling.
Has anybody ever been arrested?
I've never arrested anybody in the parking lot.
Ever been any violations of the law?
In the parking lot? I have never arrested anybody for any violations in the parking lot.
Well, are you aware of any violations of the law in the parking lot? People have been arrested?
I am not aware of any.
Thank you.
Mr. Mark?
Nothing further to say, Your Honor, thank you.
I should have asked this in a previous witness, but I assume the answer is obvious, but I'm going to just make sure. The trespass letter talks about legitimate county business. The building is a multi-purpose building. There's two state courts in there, the Superior Court and the Probate Court. There's a county office with the county attorney's office, and there's the women's crisis, or the crisis center. So that, in your, at least your interpretation, does that cover any purpose in any of those offices? That'd be correct. Okay. Based on that, do you have any other questions?
Nothing further to say,
Okay,
Your Honor,
thank you.
thank you.
You should hand. Thank you.
Your Honor, defendant's calling you Freeman.
Please raise your right hand. You swear or affirm anything you say will be the truth?
I affirm I'll tell the truth.
You have a seat.
Ian, you've heard the testimony about a group of people in the parking lot with court personnel. Now, have you ever been in the parking lot with court personnel?
Yes.
Approximately how many times?
Several, maybe 5 to 7.
And what's the time frame when this occurred?
It was all around the last week of the year of 2011.
And to your knowledge, has there been any other protests in the parking lot that have occurred?
Since that time?
Before or since that time?
Not that I can recall.
Now, just speaking for yourself, what was your purpose of being in the parking lot?
The reason I was there was to ask some questions of the court employees because as a member of the media, it's impossible to get anyone on the record inside the courthouse, inside the building itself, because of camera restrictions that have been in place for the court lobby. So I wanted to ask questions of court personnel on the record, being that they're public employees, so they should be able to be on the record when they're on the job. Unfortunately, I'm unable to ask those questions inside the building due to prevention of me using recording devices. So the only other place to ask those questions would be outside the building when those people were leaving. We also, since it was the holiday season, turned it into kind of a multi-purpose event where questions were being asked, but carols were also being sung, and happy holidays and Merry Christmas were being wished.
Now, you heard testimony from the sheriff that people were getting within 6 inches of court personnel. Is that true from your observation?
Not in my experience, and I was there for every one of those those events in the parking lot.
And approximately, what's the closest you ever got to any individual court?
Certainly nowhere in anyone's personal space. The other testimony was 5 to 6 feet away. That sounds about right. I mean, if somebody was any closer to me, that's because they would have walked past me, and I would have been, in the parking lot. It wouldn't have been a purposeful approach or anything like that.
Did you or anybody else, to your observation, ever make any type of verbal or nonverbal threat of violence or any other type of threat of physical contact?
Certainly not, and I think that the experience this board has had with my friends and I is that we are certainly very peaceful folks.
Did you ever make any threats towards any court personnel department?
Absolutely not.
The threats being made.
No way, unless Merry Christmas is a threat or Happy Holidays.
Thank you.
No further questions.
Okay, Counsel?
Thank you. Mr. Bernard, you indicated that your purpose was to ask questions of court employees. What sort of questions were you asking?
Could you call me Mr. Freeman?
No, I'm sorry, Mr. Bernard, I will not.
Why don't we settle on Ian for purposes of this testimony?
Can you ask that again?
What was the purpose, what were the questions that you were asking?
We were inquiring regarding how the court employees felt about one of their coworkers, in this case bailiff Mr. Tebow, dragging one of our friends across the floor by the handcuffs after he had been arrested. We're asking how they felt about that.
And what other questions would you have been asking?
That was the primary thrust of the questions. Anything else in particular I don't recall.
And you referred to...
That was the reason why we had come out, was because of the violence of the court bailiffs. That was what was our incentive to be there.
You indicated that you were singing what you described as Christmas carols. You heard prior testimony that may have been the music of Christmas carols, but they were not traditional Christmas carols, in that the words were different. Is that correct?
Yes, we call them chronic carols. They are a couple, most of them were songs that were taken the classic Christmas tunes and replaced the lyrics with essentially lyrics to oppose the insane war on drugs. So, for instance, they would focus on, let's see, drug war cops are raiding the school is one of the songs that we sang.
Did you ever have any songs that related specifically to employees at the court?
Later on in that particular window of time, there was one song that was directed that had lyrics with a modified lyric of Tebow to have to do with the court security officer who was particularly violent and rude towards people. So there was one song in particular.
Do you remember what the words were?
Tebow Baggins, I believe it was. The lyrics are online, but it was a takeoff of an old Leonard Nimoy song about Bilbo Baggins from his series of books, the Lord of the Rings series.
Did you at any time consider that asking such questions might create a sense of discomfort with the employees who were simply attempting to leave the court and get home at the end of the day, or come into court at the beginning of the day in order to start their employment?
Well, if that's how they felt, I'm sorry. It's not my intention as a member of the media attempting to hold government employees accountable to be concerned with how they feel about the questions that I ask to hold them accountable. As public employees, they should be subject to people asking them questions about their job.
Does that include being subject to, for instance, having their license plates videotaped?
I think that if you're a person in a public place, especially public workers, then you're subject to being recorded. I mean, there's plenty of case law that in court decisions like the Glick decision out of Boston that recently made it very clear that all public employees are subject to being recorded while they're in the course of their public duties. And in this case, because I couldn't go into the courthouse property the actual courthouse building to record these employees, recording them on their way to and from their cars was the only other option.
But they're no longer in the course of their public duties, wouldn't you
you agree?
Well, that doesn't matter. They're in the public view, and anyone that's out in public is subject to being recorded.
But you would admit, you would agree that after 4 o'clock and, before they walk into the building, they're officially not, they're not working, they're no longer working in the context of being a public employee.
I don't know how those things are defined. To me, they are always, like, I am a talk show host by profession, and even though I'm not sitting in my studio right now, I'm subject to being asked questions by anyone who wants to ask about what my job is or what it is that I do for a living. I'm always a talk show host, and similarly, these people are always government employees. If they don't want to answer the questions, they can just walk right on by.
And when they walked on by, did you continue asking questions?
Well, not all of them walked by. We actually had pleasant conversations with a number of them. You haven't called those folks in, but the video footage that we recorded those conversations, including one of the judges from the courthouse, I believe, because he was parking in a judge space, who had very kind things to say about us and our right to be able to record and hold people accountable. I didn't answer your question, though. Can you rephrase it?
I think you answered.
Okay.
Okay, nothing further,
All
Your
right,
Honor.
thank you. Any redirect? No. Okay, thank you. You can have a seat.
Your Honor, the defendants have no further questions.
All right, so where do we go from here?
Okay, the state has just 3 further witnesses, Your Honor, and they should be relatively short. The state would call Jennifer.
Stand for a moment, please raise your right hand. You swear or affirm that anything you say here will be true. Have a seat, please.
Good afternoon. Do you recall a period of time at the end of 2011 when the defendant and others were outside in the parking lot upon the morning hours when you were arriving to work and in the evening, late afternoon when you were leaving work?
Yes.
Just for the record, you're going to have two defendants. Perhaps you better just identify them. When Ian Bernard and Lynn Sarasky were in the parking lot. And
Yes.
thank you. When were you primarily faced with them? Was it the morning or the afternoon?
Actually, in the morning I was warned, so I purposely parked in a different spot and walked in through the front door because I was called and told to park somewhere different. And then in the after work is when they were at the door waiting for us.
Okay. How did you feel having to park at a different location, having to be warned that you'd have to face that in the morning?
It was frustrating and upsetting.
And in the afternoon, when you left, you indicated that you left with your coworkers. What was going on that made you feel that you should leave with your coworkers?
Because they were videoing and asking questions and getting up close to us.
How close?
Well, we had a deputy that was out there a couple of times. 'Cause I was on vacation for a lot of it. So the few times that I went out, it wasn't as bad, because there was a deputy there
Well,
that
wait
would
a
try to
minute,
keep it.
I would just for hearsay purposes here, ask the witness just to
I'm
speak
filtering,
to.
I'm filtering it. But just try to keep your answers to what you know specifically, unless you're asked a different kind of question. And you can-
Thank you. So, how close did they get to you when you were leaving?
They were just waiting for us at the bottom of the stairs. And then we would pass them. And then once we would start going to our cars, they didn't follow us to our cars. The
Okay.
days that I was involved.
On the days you were involved, they didn't follow you to your cars. Did you, when you left, how close were they? Were they a foot from you, 2 feet, 6 feet?
I mean, they were, when I passed them, they were right next to me. I mean, right, I could touch them.
Okay. And how did that make you feel, being that close to them?
Uncomfortable.
Did you have any no, let's strike that. Did things get better after the no trespass order was served?
Yes.
And how did it change things for you?
We didn't have to really worry about coming into work or leaving work, being harassed or bothered.
Does everybody leave the clerk's office at the same time?
Not normally.
You've indicated, though, that you left this group. Does that mean that when this was going on, the normal operation of the clerk's office had to change and people had to leave at the same time? Or did leave at the same time?
Yeah, because actually I got stuck waiting on someone at the window one day, and everyone still waited for me, and we all left as a group.
Okay, so it would be fair to say that it did, the activities did impact on the normal operation of the court.
Objection,
Sustained.
Did how did having everybody have to leave at the same time affect the operation of the court, of the clerk's office?
I mean, we had to wait for everyone to make sure everyone was ready before we left.
From your perspective, was that, strike that. Do you remember questions that you were being asked when you left?
Not really. I tried to just kind of block it out and ignore them.
Okay. Nothing further, Your Honor.
No, I'm sorry, yeah, Your Honor, I have no questions.
Thank you. You still have to keep testimony to yourself here for a while, but you don't have to go back to work.
It's David Colpan.
Please raise your right hand for a second. Swear or affirm anything you say here will be the truth.
Yes.
Have a seat.
Good afternoon. Are you an employee of the Cheshire County Superior Court Clerk's Office?
I am.
And in the last, approximately the last week of 2011, were you exposed to various activities in the Cheshire County Superior Court parking lot area that upon your arrival at work and upon your leaving at the end of the day?
Yes.
And could you describe what those activities were?
When I first arrived to work, there was 3 people standing out in the parking lot with video cameras, and they videoed my car and my license plate, and when I got out, they were singing Christmas songs and followed me to the building until I got inside. They would wait for us outside when I went to leave. They'd stand in a horseshoe at the bottom of the steps, asking questions like how I felt about the bailiffs and just stuff like that.
And do you recall what they videotaped?
They videotaped my car, my license plate, me.
And how did that make you feel?
Very uncomfortable. I mean, I'm just doing a job. You know, I got 2 kids. I don't want that. It's kind of scary.
It was, you said it was scary?
Yeah, I mean, I knew it was gonna go live, you know, and I don't know what people would do.
Did they ask you questions?
Yes, they asked me about how I felt about them having to stand for the judge and, you know, just stuff like that. How I felt about how the bailiffs treated them and the judge. Just that.
Would you have, just like that, thank you, nothing further.
Counsel?
Thank you, Your Honor.
Thank you. You're excused. Can't discuss your testimony.
Yes,
Mr. Ross, let's go back.
thank you.
And the state's last witness will be Tory. With an I or T-O-R-I.
Swear or affirm anything you say here will be the truth.
I do.
Please have a seat.
Thank you.
Good afternoon, Tory. The last week of 2011, do you recall incidents at the end of the day when you were leaving that required you to leave with everybody else?
Yes, I do remember.
And from your recollection, what were those incidents?
I remember leaving with my coworkers. The defendants in question were outside of the courthouse with cameras. They were near our cars, I believe filming our cars and our license plates, and it just made me feel uncomfortable that they were doing that.
And why did that make you feel uncomfortable?
Just the thought that maybe they would find out who we were, maybe follow us back to our homes, sit outside our homes and, you know, approach us there.
Did you have any contact with them in the morning, or was it just in the afternoon?
I believe it was just the afternoon.
And do you recall how close they got to you when you were leaving?
I know they were just at the bottom of the steps out back of the courthouse, but they were not that close to me.
Thank you very much, Jordan. No further questions from the state?
No questions, John. Okay, you're all set. You can't discuss your testimony yet, but you're all set to go back to work. Thank you.
Thank you.
And the state has no further witnesses.
Okay. Anything to add for this afternoon?
No, we have no further, there's no rebuttal testimony or witnesses. I said I would like, just because there's some new legal issues addressed here, I would like an opportunity just to respond to that with some sort of legal information.
Okay. Are you going to be doing the same, or?
State might, it depends on some degree on what it
I
is.
mean, the issue is pretty much squarely presented, correct? I mean,
Yes, and the state's, and a lot of the state's argument also is included in its pleading, which was the state's answer and objection to the defendant's motion to dismiss.
again, I guess how much time?
Correct, 10 days, John.
Sure. 10 days would be enough?
Yes.
Okay, and then, so the issue is whether, I guess the issue is whether just the strict reading of the elements of the offense is all the state really had to show here, and you say that you have to get behind that with respect to the validity of the order.
Well, I guess that's the issue that's been raised
Right.
today. I think we're still, I think still before the court is our basic argument that the statute is unconstitutional. I think some of the testimony today does bear on that. So that's what we are primary focus.
And do you going to supplement the constitutional question, don't you think?
Well, I think it's more a matter of applying, now that we have a factual record, which we didn't have before. Simply
This is an as-applied case?
Yeah, basically applying I always think of as applied and on its face as being related to statutory issues. So this is sort of a little bit different, but.
I just may need help from both of you, just to make sure I'm addressing it the way you think. At least I want to make sure I understand how each of you wants me to address that.
Again, the defendant's position is essentially that the order violates their constitutional rights, and that makes the trespass prosecution also a violation of their rights, because the prosecution is predicated upon that order. It's sort of an unusual trespassing order, because the state has now argued today that they weren't really banned in the first place, they just had to get permission. And so I'm not sure, maybe an issue there whether it even is a trespass violation, whether the order is not a complete banning order for them. Look at that.
So 10 days would be enough?
That would be sufficient.
Yeah, maybe 2 weeks, we could get 2 weeks out.
Sure. Actually, given the holidays and vacations, I'm not going to be getting to this, unfortunately, right away. So if you want a little bit more time, I'll give you more time.
Maybe what I can do is just discuss that with David, and then we'll give the court a date.
Just let the clerk know when we can expect.
Very good, thank you, Your Honor.
Thank you, Your Honor.
All right.
That was hysterical. Oh my gosh.
Cat is on the ropes.
I know, all Sheriff Flick has to do is say sorry. And this whole thing will be done. Like, I made a mistake, I overstepped the bounds.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.